We appreciate you taking your lunch hour to be with us for this training.
Joining the meeting.
We're very excited to work with all of you for Citizenship Day and to go over all of this information. So a few sort of housekeeping things, especially for those of you on the phone. So we're using the, you should be able to see and follow along with the screen if you click the link that we sent, or with the PowerPoint, and we'll let you know what slides we're on. If you have trouble hearing, I think there's a chat option, and you can let us know if you're looking through the online link. So, or you can send an email. Probably the easier thing is just to send an email to me, Lily, or to Sarah. We both are here, and Sarah was the one who sent out the training reminder, so you can just reply to that and let her know if there's any issues going on. So a quick overview of what we're going to cover over the next 80 minutes or so. First, we'll hand it off to Emily and Greg, our attorney trainers, to go over the naturalization eligibility requirements and relevant sections of the new N400 form, the form that came out in the spring of 2014, going over basic eligibility requirements and then some red flags and sort of who shouldn't apply, deportation, removal, etc. And then I will come back on and talk over some information about what to expect at Citizenship Day and make sure that everybody's questions are answered about what they need to know and where they need to be. I am Lily Wiggins. I manage the Washington New Americans program, and this is a program that works in close collaboration with the Washington chapter of the American Immigration Lawyers Association to host Citizenship Days. We do these larger Citizenship Day events twice a year in October and April, and we also do some smaller clinics where there is demand throughout the year as well. And we are thrilled to have all of you as volunteers. We can't do these clinics without you, obviously. And we do a lot of work to make everything as smooth as possible, but really we can't provide the services and the quality of services that we provide without your help. So we really, really appreciate all of you. We know you're giving up your day, you're giving up a couple hours today to do the training, so just huge thank you, can't thank you enough. And with that, I will turn it over to our attorney trainers.
Great. Now, is this the microphone that I'm supposed to be speaking into
There's
as well?
two.
There we go. Okay,
Yeah.
So you'll be letting people know if there are any issues.
Yeah.
Thanks very much for everybody who's participating in this on the phone and in person. Emily, Lily, and I have done a lot of work to try to tighten this program up a little bit and give you better information, more consistent, especially because it covers some areas that all of us are going to be encountering people who we've never met before. We don't have any history of it. We're just getting it and quickly making some decisions. So we've tried to do these in a way that you'll be able to get a quick idea of what you should be doing and be able to review it and get it off to the next stage of the process. So let's talk about the basic naturalization eligibility requirements. They're listed on the front of the N400, and basically it's the person has to be at least 18 years old. So if you're talking to a child, you want to be thinking about that. A lot of times people ask, do I even qualify? They have to be a permanent resident, so that's another issue there. They have to meet the certain standards of residency requirements. We're going to talk about what those issues mean. Physical presence requirements, which are related to but separate from the residency requirements. They have to show that they can speak, read, and write English to a limited degree. It's not significant. A lot of people are worried about that, and there will be some screening that people from the program will be doing to screen out people who might not qualify within the time that they'll be taking doing the meeting with the immigration officer. They have to, by and large, show a knowledge of U.S. history and civics. They have to be willing to take the oath of allegiance. We'll talk about that in a bit. And probably most significantly, or one of the most significant things, they have to show that they meet the good moral character requirement, which we have a lot of slides on that issue, and we spend a lot of time going through those. So let's go on to the next slide. And I've just hit the arrow button and nothing's happened on this. So
I'm going to come help you.
to be sure. Just open that little, that. I'll
You gotta
just
click
tap
up
it.
there,
Thank
yep.
you. There we are. I see you. Thank you very much. All right, so let's talk about the residency requirements as the first issue. First, person has to have had lawful admission to the United States, and that's going to work out pretty well for most of the people who have a permanent resident card that they're presenting it to you. They have to have been a permanent resident. There are two periods of time that we're talking about, either for a 5-year period of time, which probably the majority of people you'll be talking about came in and they'll show that they've been a resident for at least 5 years. But there's also a 3-year aspect that can be met, and so there's going to be some real benefit that some of the people can have if they're able to qualify under the 3-year time frame. So, but to understand the 3-year time frame, remember it's if at the time of filing, not at the time the interview is going to occur months later, but at the time of filing, that person's been married to a U.S. citizen for a full 3 years. They already have to have been married to that person for 3 years and living in a marital union. So if they are coming close to having been married to that person for 3 years, or if they're coming close to having been a permanent resident while married to a citizen for 3 years, they're not quite there yet. They have to meet the standard at full 3 years at the time of filing. Another kind of interesting, not quirk, but way to look at it, issue for some people is asylees and refugees, establishing when did they become a permanent resident. And there's an issue we call the rollback issue for them. A person who is an asylee, they are a lawful permanent resident from a year before the permanent resident decision. So a person might say, but I haven't, I only applied for my card X period of time ago. That's not enough time. And yes, it's a permanent resident from a year before they applied for permanent resident. Refugees get it from the date of admission to the United States as a refugee. So there's some interesting timeline issues there that can be helpful to consider for you. Let's go to the next slide, which is number 5. And this is an example of what the chart looks like in terms of where you're putting this information down. And you can see the 5 questions, a resident 18 years old, admitted for permanent residence, and then you get to choose those issues. It is, again, helpful to talk to a person about why they choose the 5 or 3 year window of time. Some people qualify for both. I've actually got one right now who I talked to a couple days ago. He qualifies for both, but he had a pretty significant issue in his past, relatively recent, but more than 3 years. And so we decided we're going to apply under the 3-year rule for him because he's able to get rid of some of the issues of concern that would have occurred if we'd used the 5-year standard. The next slide, I just love pushing that arrow.
You got to do it one more time because there's...
No, I think oh, there we go. I see what it is. So you can see the questions at the top there, 1 and 2 about being a permanent resident. And at the bottom there, number 7, there's a signature part there, or excuse me, the date that they became a permanent resident on that one. Thank you, Lily. I appreciate that. The next slide is the information about the residents, and so they need to put that information down. That also will help you get a sense of how long have they been there. You want to talk to people who might have moved to a place fairly recently. If they're using the 5-year standard, you're going to be able to work with that fairly easily. So I'm going to go on to the next slide. I don't know. There we go. All right. Permanent resident requirements. This is now. People say, well, can I have left the United States? And yes, you can have left the United States during that 5 or 3 year window of time, but the amount of time that you've been out of the United States in any one continuous period can be a really significant issue. And it can be enough for you to potentially stop the process and say, we're not going to proceed for a while. We're going to let you get more time in the United States. So you want to look at the absences that the person's had from the United States and look through their passports, admission stamps, things like that. An absence of less than or equal to 6 months, no problem at all. The person should be admitted as a returning resident, and that's no problem. An absence of more than 6 months but less than a year, your red flag should start going up. What was the purpose of your departure? What was your intention when you left? Look at the time period that occurred there. An absence of a year or more, significant issue, very significant potential problem. And we've seen cases in these programs where people had an absence of more than a year, and now they've been back for about 5 or 6 years, but it's still an issue that you need to pay attention to because something could come up in the background. Even though the new form now only asks for information about the absences of the last 5 years, you really want to be looking at all of their absences that they've been gone since being a permanent resident. Now, one of the reasons why we want to look at this is because you don't want to be a part of a process where a person who has a permanent resident card, who probably could get it renewed, but by filing for naturalization might actually be determined to have abandoned their permanent residence in some time in the past and then lose their status. So that's something that we really want to be cautious about, and we've actually stopped a couple people sometimes from applying because of that significant absence in their past. So it is definitely something to watch for, and again, not just in the 5-year window that you're now looking at in terms of what's on the application form. All right, we're going to go to the next slide. When you're looking at this 5-year or 3-year window, you can actually apply. There's a 3 months residence requirement in the CIS district where the person is filing, and so most of us are here in Western Washington. So some people might have recently moved here, but remember it takes about 3 to 4 months at least. 5 now? Yeah, it's taking about 5 months between the date of filing and the date of the interview that occurs. And so for people who are using the 5-year window and who are just kind of coming into this area, they'll have met that requirement. And now you see at the bottom, you can file as many as 90 days before the residence period is completed. So looking at how long recently they moved to the area is helpful to deal with. Let's see. And again, some people in the middle bullet, some people say, well, when I file this, can I leave the country now? Am I allowed to leave? And they are actually allowed to leave the United States. They're just not allowed to be out of the country, or shouldn't be, long enough to break that continuity of residence again. Now, because the interviews are generally being scheduled between 4 and 5 months or so, it's really unlikely that they break continuity of residence, but it's, those long trips outside the United States are something that they want to be very cautious about. But certainly, a couple days, a couple weeks, not a problem at all. They are allowed to leave the United States during that time. Again, though, you're going to be looking at that whole 5-year window of time, and you want to make sure that by the time they're interviewed, they've still had a 5-year continuous period of time in the United States, including those occasional breaks. Looking at the next slide, physical presence requirement. So it's a slightly different issue now. A person has to be physically present in the United States for at least 1/2 of the time that they're using, either the 5-year window or the 3-year window if they're married to a U.S. citizen. So again, they can have left the United States. They can't have left in large chunks of time that break that continuity. And overall, they must have been in the United States at least 1/2 of the time that they're doing that. Some people have had the kind of view, hey, I'm a permanent resident as long as I'm in the United States at least 1 week a year. That works. It doesn't work like that. That's not the issue that you want to be dealing with. You want to have a person who's been able to show that they've been present for at least half that time. I don't know if we have, sometimes we have the information about how long that half time is.
30 months or 18 months?
Yeah, 30 months if you're using the 5-year window, 18 months if you're using the 3-year window of time. Okay? And
I'm going to move your arrow.
there we go. Now I see where it is. All right. And the last slide that I'm going to do at this point before I turn it over to Emily, if you look on part 8, this talks about the time period and you calculate that time. Lily, correct me if I'm wrong, we're actually gathering information about the entire period of time a person's been out, not just this 5-year window. What's the...
It's a good idea to ask,
Yeah.
because of the abandonment of residence question, but the form only asks for 5 years.
Are we in the program, though, are we gathering the whole period of time a person's been out?
We're asking people to bring information about travel outside that period.
So if you didn't hear that, we're asking people to bring information to show that, but because we're not being asked to provide that, it might not be something you look at. I think as an attorney, it's really helpful to go through that just to be more comfortable that you don't have a person who had some huge gap of time and didn't have a reentry permit or something else that allowed them to come back in. But this is the calculation used. It's very helpful. And this will have been completed for you before you actually meet with the person who is presenting themselves to you, so it will be helpful there. I will turn it over to Emily now.
All right, can I sit here?
Sure, yeah.
I have a quick question.
Yeah.
Can I ask a question? So you recommend for the section 8, I guess part 8, even if the person is married to a citizen, still provide 5 years of travel history and not 3 years? Because it seems that would be the relevant period, right? That matters.
So the question was, if you're doing a filing based on a 3-year marriage to a U.S. citizen case, do you present 5 years still? I think there's been some discussion in the chapter about that. The question on the form says 5 years, and so I think most people are providing 5 years, although I think correct me if I'm wrong, I think there's been some discussion, some people have said, I'm just using a 3-year thing, I'm only going to provide 3 years. Emily, what have you heard?
Right, I mean, that's what I would have done. If you're applying under the 3-year rule, you only need to show the continuous residence for 3 years. So I would just list that. Now, because people are going unrepresented after applying through Citizenship Day, I don't know, just to be safe, I might put down the 5 years and maybe just put in a little note that I'm applying under the 3-year rule and only need to show continuous residence for 3 years. So I might just add that extra since you're not going to be representing them at their interview.
May I ask a quick question? It might be asking for legal advice, but so for Citizenship Day purpose, like I had a person coming in and she has been out of the country 1 day short of a year. And because our representation is so limited, in that situation, should we just tell her to wait as opposed to like go ahead and complete her forms because, you know, that could be an issue going forward with the interview and unrepresented?
You want to repeat the question, then we'll
Okay,
both answer.
so the question was, if someone comes in and they've had a 364-day absence, so just short of the year, that automatically breaks the continuous residence, should we advise them to go ahead through Citizenship Day or have them wait because there could be an issue in their case? That's the question. I mean, it's true. There is an issue, right? Because it falls into that period of time, 6 months to a year, where USCIS could find that they've broken continuous residence unless they can provide evidence that they didn't. So unless they came in hand with that type of evidence and you saw, you know, what showed that they maintained their ties to the United States during that long trip, unless they have that, I would probably, yes, advise them to get representation. What do you think?
Yeah, I think that could be a pretty significant risk if you're talking to a person and they just kind of tell you out of the blue, well, this is what I did and this is why I did it and this is how long, you know, what my purpose was when I left. You don't know whether they're going to actually be able to say that and provide evidence of it. Certainly they were admitted back into the United States. Some officer let them in, but we know that doesn't always, you know, make the case when you go in later. You might let that person know there's a significant risk. We don't think you should proceed. And if you're not going to go in with representation if you were to file this. So I would, you know, because your name's going to be, you're going to be signing at the end of that, you might want to say, I think this is too dangerous to put forward without seeing the actual documentation. Another question.
Yes. How about if somebody absent for like almost 900 days, like almost to the limit, but they haven't and they apply, and they would like to go abroad after the application due? What would you suggest the client?
So the question is, what if a person just is at the one half of the time right now,
Right.
and they also say,
Joining the meeting.
and I plan to leave the country after this.
Right.
I would probably carefully let them know, you know, there's this standard here that you have to meet this standard, and one day beyond that could be a problem for you to get citizenship. And so when you travel frequently, especially if you're talking about a relatively long trip, you may have other issues that occur while you're gone that prevent you from coming back when you intend to come back, and that could wipe this whole issue out. And in fact, it could be worse. It could if you are gone for more than 6 months or something like that, you could have other issues there. So I'd be cautious about it.
So the way they count is not just
It's
stuff on application. Back 5 years is they also count about the interview from the interview to application.
the 5-year window. I consider it kind of a three times. I consider to the date on the date you file. I consider on the date of the interview, and then I consider on the date the naturalization actually occurs. And I look at all three of those. Emily, what do you?
Yeah, I mean, that sounds reasonable. So the date they file is counting back when the 5 years of continuous residence and physical presence will be counted. Then from the date of filing to the interview, I would suggest they are here at least for half of that time for the
Okay.
physical presence requirement. If your person's close, like Greg was saying, like you don't know, what could happen that might tip them over that when they're. But yeah, the physical presence is counted back from the date of filing. But then they also have to maintain physical presence for half the time from filing to interview. So, I don't know, if it's close, I would probably advise people to wait, or, wait for their travels, or if they could, if it's not necessary travel.
And the interviews don't always, the swearing in ceremony doesn't always occur on the day of the interview, so you got some changes that could occur with all sorts of stuff for people.
In the interest of time.
Okay, shoot, no, sorry.
Yeah.
Okay, so let's turn to the English language requirements. We're on slide number 11. Yes, we are.
One more.
Nope, it's here.
Okay. Okay, so there's, so the English language requirement, their applicants are required to speak basic English, and so the officer tests their spoken English at the interview when they're interviewed about their application. So at Citizenship Day, you might be faced with someone who brings an interpreter because they want to make sure they're giving accurate information and all that. But at some point, you're going to want to make sure that they're able to answer questions about their application at the interview. And I think, remind me, Lily, we do English screening of people when they first come in. Okay. So you may be interviewing them to get accurate information, but they should also be able to respond to basic questions in an interview. Also at the interview, they'll be tested on their reading and writing abilities. They'll have to read and write 1 or 2 basic sentences. All the vocabulary required for that will be provided to them. Either they could get it online at the USCIS website, or we'll have copies of the reading and writing vocabulary at Citizenship Day. And they say it's about a 4th grade level at which they have to perform. That it seems a little bit higher, especially given some of these complicated questions on the application. But now there are exemptions to the English language requirement based on the person's residency and their age. We call them the 50-20 and the 55-15 rules. If someone is at least 50 years old at the time of filing and has been a lawful permanent resident for 20 years, then they don't have to do the interview in English and show that they can read and write in English. They can have an interpreter with them. They still have to pass the history exam, but they can have an interpreter. Same with 55-15. If they're 55 years old at least or older and have been a resident for 15 years at the date of filing, then they can get that exemption. Similarly, if a person is 65 years old, and actually this is one of the history ones, but we'll get to that in a minute.
Yeah.
And then there's an additional waiver for people who are unable to meet the English requirements because of a medical condition, and this is called the disability waiver. It's a separate form. A doctor or psychologist completes it. So it won't be something we will be moving forward with at Citizenship Day, but if you do have an applicant who maybe seems elderly and unable to understand things, or who their family member says has certain conditions, maybe dementia or stroke or other things, then you might suggest that they see if they're eligible for a disability waiver.
I have a question.
Yes.
Are the folks coming going to be pre-screened for that, or should we primarily screen for that?
So that will be screened at the English screening, right? Oh,
And that's a good question too, because on the
Do you want me to repeat the question for the
Oh,
people
yeah.
online?
Go ahead. Yeah.
So Nate, the question was, will people be screened for disability waiver eligibility at the beginning of Citizenship Day? And Lily is saying,
yeah, so I don't know if people can hear me. It would be something that would come up hopefully when we do the initial intake and English screening, if there seems to be a problem. But it's possible that somehow if they got all the way to you, they may get all the way to you. But the citizenship, the N400 form will be completed before it gets to you, and there's actually questions on the form, which I think is the next slide, about do you have a disability that prevents you from makes you need modifications to this process, and then also screens for whether they're eligible for any of the exemptions. So that will already be answered before they get to you.
okay. So yeah, what Lily was talking about is on page 2 of the N400. There's a specific question if you're requesting a disability waiver, and then there's a couple of questions to see if you fall under one of the English exemptions that I just talked about. Okay, so going back to, whoops, I'm going backwards. How do I go backwards? Okay, so turning now to the history requirement. Applicants study off a list of 100 questions related to history and civics. At their interview, they'll be orally tested on this material. The officer
Joining the meeting.
will generate a list of 10 questions
Question
randomly.
one.
And the applicant has to answer 6 correctly. When they get 6 right, then the officer stops asking anymore. And again, as I mentioned before, even if they're exempt from the English requirement under one of the 50-20, 55-15 rules, they still have to pass the history test in their own language. And an additional history exemption is if a person is over 65 years old, 65 years or older, and has been a resident for at least 20 years, then they can study a reduced number of questions. It's only 20 questions they have to learn, and those questions are marked on the 100 questions list. And again, you can also qualify for a disability waiver for the history test if you have a medical condition that prevents you from learning. Again, this is just the disability waivers. It has to be a medical condition determined by a doctor or psychologist. It can be completed by an MD, a doctor of osteopathy, a DO, or a clinical psychologist. And again, that's slide 14 shows where on the N400 these questions come up. Oops. All right, so then a final or another requirement to be eligible for citizenship is the applicant needs to be willing to take an oath of loyalty, an oath of allegiance to the United States. And the person needs to be willing to bear arms or carry weapons to defend the United States. Some people might be opposed to doing this because of a religious or philosophical belief, and they can request a modified oath, which means they just don't read that part of the oath that talks about bearing arms. Usually that requirement can be met with a letter from that person's religious denomination. I've even had it done with a person writing a statement about their philosophical beliefs about why they don't believe in fighting or violence. But anyway, those questions about the oath are the final questions on the N400, and the officers ask every question at the end of the interview. The oath is also printed on the last page of the N400, so it's a good idea to review that with them so it's familiar. All right, and turning back to Greg now to talk about the big, more complicated requirement, good moral character.
This is going to take us through a pretty large number of slides then on this material because good moral character is ill-defined and a really broad subject. So this first slide here, number 816, is kind of an introductory slide for you all to get a sense of what you're looking at for good moral character issues. So you need to show that you have GMC during the statutory period of either 5 years or 3 years. So you're starting to see why choosing a 3-year window, if that's what you have, it could be better if there was an issue that occurred 4.5 years in the past. Otherwise, you'd be telling a person perhaps to wait to file it. Now, there are, the person has to have these through the oath ceremony, and there are, we'll talk about the bars now. There are bars to showing good moral character. There are certain mandatory bars that some of them, if they ever occurred within the issues that we'll talk about in a minute, that's it. You're not going to qualify or be able to show good moral character. And there are other ones that are temporary and only apply during those particular statutory periods. Then there are discretionary bars, and these are things that can be considered, but they're not necessarily bars to being able to show good moral character. So we'll go to the next slide. Which are the 3 screening tips, ways that you start out through the process of trying to make the decision. Is this person going to be able to show good moral character or not? So one is, are they barred? Because if they're barred, they're barred. So there's not going to be any real basis to proceed. But if the person, and the second question, could this person otherwise be denied based on lack of good moral character? These are the discretionary issues. So questions asked, if the applicant has demonstrated good moral character during the statutory period, that 3 or 5 year window, CIs can't deny the application based solely on acts that occurred outside of the statutory period. So if those events did occur, but those are the only bases for the denial for an issue, these CIs can't deny it. But it's required, it's next bullet down, to evaluate the claims of good moral character on a case-by-case basis. And this is where it starts getting a little bit more dicey and more complicated. They're going to be taking into account the standards of the community. I think people might have remembered a couple of years ago there was an issue with the guy with clams. I think he had gathered too many clams, and so there's some issues, what the local community had there. And there's another issue to think about here, aside from good moral character, is by presentation of this information going to show that the person is actually removable and there's no relief. So the person's actually, they've got their permanent resident card, things seem to be going fine, but by providing this, are you going to actually show that they're removable and there's going to be, again, a more serious issue for them rather than just being told you can't naturalize. The next slide, we just wanted to talk about the mandatory bars to being able to show good moral character. There are 2 bars that are permanent and they're mandatory. If a person is convicted of murder at any time, that's it. They don't qualify to become a U.S. citizen, to be able to show good moral character at least. And if they have an aggravated felony, and those of us who were practicing back in November 29, 1990, when that term came into effect, that also is a bar to being able to show good moral character.
All right, so now we're going to go over some of what we're calling temporary bars, because they're acts or things that happen during the last 5 years or 3 years, and once they get older than that, they're not mandatory bars. They're not something that absolutely bars an applicant from showing good moral character. So these are listed in the INA in section 101F, and there's just a list of them, things that if the applicant has done these within the last 5 years, then they're unable to apply for citizenship until those move out of the statutory period. Okay, so the first one, habitual drunkard. There's not much definition of this other than an old case from the BIA that talks about it being akin to a chronic alcoholic. In that case, the person had a doctor or someone who determined that this person was a habitual drunkard, and so it wasn't something that the USCIS officer or INS officer had determined. It was a doctor's determination. Having said that, even though that's sort of
joining the meeting,
an old case, if an applicant has a lot of DUIs, either recently or not so recently, that could be an issue that comes up, and you'll want to, just talk to them about how that condition has been dealt with or resolved or whatever. Secondly, illegal gambling. If the person's income comes mostly from illegal gambling within the statutory period, that's a bar to showing good moral character. If they've been convicted for 2 or more gambling offenses within the 5 years, that's a bar. And then also if they've given false testimony in order to get an immigration benefit. So if they've been speaking with an immigration officer under oath and have given false information during the last 5 years, that could be a bar to good moral character. And it doesn't necessarily have to be something material or relevant that they told an untruth about. It's just the fact that they told an untruth, since this is a good moral character determination. So one way this might come up is that if someone recently applied for citizenship, say 2 years ago, they misrepresented something at that interview and then were denied for it. 2 years later, if they try to apply again, they could be denied again. So.
All right, the next slide is a continuation of the mandatory bars to showing good moral character. Again, they're temporary in that if they occur within the window, they're bar. If they're occurred outside, they're not mandatory bar. These are fairly easy to be able to look at the information that you have, and they should have information with them there at the time. You don't want to be advising on these issues or making decisions if they don't have the actual documentation. Confined to a penal institution with a conviction with an aggregate of 180 of more than 180 days. It's more than, right?
180 days plus. Yeah.
Days. The next 2 include the terms conviction or admission, and we want to point out that there are some definitions in further slides, slide 22, 24, 25, and 26, that relate to what a conviction is and what an admission is. But if they have a conviction or admission of a crime involving moral turpitude, that can be a mandatory bar. But there's a petty offense exception. We've given the citation to the INA. If the person had only one crime involving moral turpitude and the maximum possible sentence is 1 year, and then they were actually sentenced to 180 days or less, then that's the petty offense exception, and they're not subject to the mandatory bar. So there's a really great thing that can happen there for if that's all that you've seen. Same thing with number 7, or not same thing, but number 7 is conviction or admission of a controlled substance offense. Remember, marijuana is still a federal issue, not just a state issue. So that's an issue to be dealt with. And then conviction of 2 or more offenses with an aggregate sentence, the actual sentence imposed, of 5 years or more. Not the sentence that could have been imposed, but the actual sentence imposed. That would be a mandatory bar if it occurs within the window.
All right, so, and as you noticed, a lot of these bars listed in 101F refer back to admissibility grounds in 212A. So that's what those citations are there for. Okay, some other temporary bars, if they fall within the statutory period. If the officer has a reason to believe the person's a drug trafficker, and so that could be something that comes up on their background check, not necessarily a conviction or admission even, but something that makes the officer believe that the person is involved in drug trafficking. Number 10, if the person has engaged in prostitution or commercialized vice. And there are certain requirements that have to be met. For example, engaged in means not just a single act of prostitution. You need repeated acts. It has to be within 10 years of admission. Another thing to keep in mind, though, if someone has been convicted of prostitution, that's also a crime involving moral turpitude. So even if they don't fall under this good moral character ground, if they have a conviction for prostitution within the 5 years, that could be a bar. Number 11, if the person's an alien smuggler, again, you don't need a conviction for this, just that determination being made by an officer. You know, if a person was convicted of alien smuggling, that happens to be an aggravated felony generally, so that person would be permanently barred from showing good moral character anyway. But if for some reason something came up on their FBI background check, or there's something in their history that makes you aware that, say they were stopped at the border coming in with their sister who was undocumented and were fingerprinted, if they tell you that, then that's kind of a red flag that needs to be checked out a little bit more. They need to do a FOIA request, find out what happened there, see if there's any way they could be determined to be an alien smuggler. And finally, if the person's come to the U.S. to practice polygamy, then they could be barred for not having good moral character. Again, this is not just someone who's a bigamist or who happened to be married to 2 people at the same time, or whose divorce wasn't properly done before they married someone else. It's someone who believes in the idea of having more than one spouse and is coming here to do that. Okay, so let's move on to slide 22. So a lot of these bars to good moral character involved having a conviction for a certain type of offense, usually a crime involving moral turpitude. And so whether or not something is a conviction is defined under immigration law, and it's there at 101A, 48A. And the definition of conviction is a formal adjudication of guilt entered by the court, or if the court withholds adjudication, a judge or jury has found the alien guilty, or the alien's pled guilty, or nolla contendere, or has admitted sufficient facts to warrant a finding of guilt. So there's various ways a person can, various parts you have to look at when you're determining if there's a conviction. And in addition to one of those things, there has to be a punishment or a penalty or restraint on their liberty. So that could be probation, it could be jail, it could be community service, it could be having to go to classes. Various things could fall under that second prong. So just because someone comes in and says, oh, I had a conviction for theft, but it was all taken care of, it was dismissed, that needs, what happened in that case needs to be looked at a little more closely to see, was it actually a conviction, even though the final outcome might have been dismissed. And again, we're going to have individuals at Citizenship Day who will be, their sole job will be to look at criminal records to see, you know, if what happened in the person's history is going to be problematic.
So that reads to me to include something like a deferment situation, right? Where
Yes, potentially.
they might not actually have been convicted of anything, but they had to do community service, could have been found guilty, and thus that's kind of where this gray area comes in. Is that what I'm?
Right. So, yeah, I mean, deferred prosecution, pretrial diversion, stipulated order of continuance,
Yeah,
all those
all that
things,
stuff.
you know, that don't necessarily scream out, this was a conviction, but it may have been if both of those prongs are met.
Gotcha.
So, yeah. And often, yeah, I have a lot of people who will come and say, oh, but it was dismissed. You know, isn't that fine? Well, not necessarily. It just depends what happened in that process.
Right.
Okay.
Okay.
All right, so then this makes it very important that the applicant has their criminal records, that someone can review it with them. Generally, at least what USCIS is looking at is the FBI record when they take the applicant's fingerprints. And so if someone, especially if someone has different incidents in different states, it's a good idea to also be looking at that. And I don't know if people will come in with that, but that's something you could recommend if someone says, oh, I had something in Minnesota and California, and it's a good idea to have them get that. Again, these aren't always complete, so sometimes you have to do other research to figure out what their arrests and convictions were. In Washington, we tend to also look at the Washington Courts website that lists pretty comprehensively an individual's interactions with the court system, and so it helps you track down cases. Also, the Watch, run by the state police, often has a lot of the same information, but that also isn't always complete. So I think at most sites we have access to run those searches if it seems like we need to on certain applicants. Are we doing it on everybody or just
Just if it seems
just
like.
yeah? Okay, and then also the bars to good moral character. Some of them were just based on admissions, not even convictions. But for something to be an admission, there's some fairly specific requirements that have to be met for it to be considered an admission. The person has to admit all the essential elements of a crime. They have to be given a definition of the crime. It has to be a voluntary thing. And they have to admit all the facts that constitute that crime. And that's sort of laid out in a BIA case and its progeny.
All right, so you earlier on at slide number, number 20, we talked about some mandatory bars to showing good moral character if you had conviction or admission of crime involving moral turpitude or, and so let's talk about what CIMTs are and what they aren't. I'll start off with what they aren't, because Emily and I were trying to figure out which is the first slide to put in there, and I guess the first one is like if you got some information, you want to be able to exclude it and say it's not an issue. So a simple DUI is not going to be a CIMT. Simple assault, even if it's domestic violence, that also is not necessarily a crime involving moral turpitude. Here in Washington, assault 3 under the RCW with mens rea of negligence is not a crime involving moral turpitude. Criminal trespass. Traffic offenses, just the base. Everybody always wonders that. I have cited some traffic offenses. Are they going to be problems for me? Just general ones like driving without insurance, no. Without a license, no. The number 6, the theft offense. It's important to understand that it can be CIMT, but if the theft included intent to permanently deprive the person of the item or whatever the issue is. But otherwise, generally, theft offenses aren't crimes involving moral turpitude. And can you talk about the categorical approach?
Yeah, so, well, I don't want to talk about it too much.
Yeah.
Except to say that because of some recent U.S. Supreme Court case law, certain crimes that previously might have been considered CIMTs now aren't. And, so if we're seeing some of these people coming in with convictions, that we probably won't be handling some of these more borderline or ones that aren't as obviously not CIMTs. So this is just to say that now in Washington, the Washington theft statutes are not considered CIMTs based on recent case law. So that's something that could go forward. I don't know how I mean, we've had some success with some of those at USCIS and citizenship applicants, but yeah, I wouldn't recommend that those people go in by themselves anyway, so we'd probably refer them out. Okay.
What are crimes involving?
Okay, so some that, like we said, CIMT is a nebulous term, but theft is generally a CIMT, except for the Washington theft statute I just mentioned, where there's an intent to defraud. That's crimes that have that as an element are often CIMTs. Felony assault with mens rea of higher than negligence, and if there's some aggravating factor. Solicitation of prostitution is now determined to be a CIMT under Ninth Circuit case law. Someone has a DUI and also knew that their license was suspended when they got that DUI, that's also now considered a CIMT. So that's different from the simple DUI that Greg mentioned.
May I ask a quick question? Will the quantity make a difference for the petty offenses? Like, we saw people like say he had like 19 driving without, he said it was just, driving without seatbelts, a couple of those citations, but he had 19.
Okay, so the question is whether someone has multiple driving offenses. Does that make a difference? And yes, even though they aren't CIMTs, they could still be held against that person as far as the discretionary analysis of do they have good moral character. And yeah, and I've actually had a case like that where it was denied.
And indeed, let's talk about the next one then, which is slide number 27. The discretionary bars. So first of all, when you're dealing with discretionary bars, you want to be looking at the statutory periods, the 3 or 5 year window. And we've given you the citation to the CFR. Unless establishing extenuating circumstances, unless you're able to establish extenuating circumstances, the following will be found to lack good moral character if the person willfully failed to support dependents. That's why tax issues and the child support are always an important part of the question. Extramarital affairs that destroy an existing marriage. I don't think I've ever seen a case that involves that particular issue. And then I think what you were just talking about, though, 19 driving offenses that committed unlawful acts that adversely reflect on good moral character. Maybe, those are potentially issues that could be one of the issues that would be part of the discretionary bars.
And again, it's going to be that weighing of the positive and negative equities, right? And using that standard of the average citizen in the community.
Yeah, and 19 or not, it'd be an interesting one to start looking at. We go to the next slide, continuing on the discretionary bars. Failure to file or pay income taxes. I guess, and so the person is asked, have you? And if a person's on a payment plan with the IRS, that's accepted then, that's okay. But if they haven't worked that out yet, that's a big issue. I'm just going to talk for a second about the fingerprinting thing. A lot of people, when they talk to you about criminal stuff, and they say, well, it just happened so long ago, it's not really an issue, it's never really affected me. And you just remind a person, you're going to be fingerprinted as a part of this process. I mean, they're going to look at all that. So it's really important to be completely full, accurate, and honest. Number 5, the failure to register for selective service. We're going to talk about that in a minute. Also, false claim to citizenship. Again, we'll talk about that, and there's a potential for deportation there if that person has an issue. Illegal voting, again, another serious offense that is part of the discretionary bar issues. And we put the asterisk there. If a person is on probation or parole, they can't be naturalized if they're still on that at the time. So that's definitely something to be watchful for and get them past that. The next slide is selective service. So at the time at the program, we're going to have the ability to access the selective service information system, so you'll be able to determine whether a person did or did not register. A lot of people are surprised by the fact that they were required to register for selective service. So, and this is the very first time that many people will have heard, what? I have to have registered? I didn't realize that. No one told me that. So it's really important to understand that these issues occur. All males age 18 through 25, except non-immigrants, are required to register, even though they don't have to serve. It can be an adverse good moral character issue if they didn't register. But once they register, if they're outside the statutory period, they can't register, obviously. And so that can become an issue. We've got information to be able to go online. We'll be able to do that on site. And we also have a document that person can actually sign there. And I think it's helpful to actually look at the person while you're asking them the question. And if they look surprised, if they look like they just had no clue that they were supposed to do that, that's, I think, a helpful indication that they would be able to sign the document that says, I didn't willfully fail to do this, I had no knowledge that I was required to do this, and that's usually something that can be very helpful in terms of the issue. We do have a status information letter that you can ask for and get it from the Selective Service Administration. I think they come within about less than a month of the time that they're requested, so they're pretty quick to be able to get those, and that's another helpful confirmation there. The next slide is voting or false claims. It's not an automatic bar. There are some people who have done it with complete lack of knowledge of the issues. There's a Child Citizenship Act exception. This is a little more complicated. We were talking about how much writing we put into some of these. Someone whose parents are U.S. citizens, and the person, and before the person was 16 years old, and they reasonably believed that they were a citizen at the time.
Joining the meeting.
At the false representation, they can still get good, be able to show good moral character. They essentially thought they were a citizen, and they weren't. If there was a conviction for this, it may or may not be a crime involving moral turpitude. It just depends on whether it's a felony conviction or not. And then it's important to understand, if you're all ALA members have access to this, is a Yates memo that was issued on May 7th, 2002. It talks about really helpful guidance on how to deal with issues for naturalization applications for people who unlawfully voted or falsely represented themselves. Very, very good information. I suggest you read it, and we've given you the ALA document there to be able to access it. And you will encounter those on occasion.
Right. And those two issues, the voting and the false claim, that's sort of more for your information. If a person presents with those issues, of course, they'd want to be referred out. But, I mean, just so that you can tell them you're not necessarily barred, but there's a lot of things that need to be considered. This could be a removal ground, so just information to pass on to them. All right, so there are a number of chunks of the N400 that include questions related to these issues we just talked about, to good moral character. Part 11 has many questions, yes and no questions, related to the good moral character issues.
Yep, it's a good
Oh,
there.
it did.
There we go. There.
Okay. Oh.
There we go.
There's a number of, again, more on page 14, part 11. I had my first interview actually with the new N400 this week, and they asked maybe 2 questions from these pages. I mean, a lot of it's kind of similar and repetitive. Again, more on page 15.
And on this particular page, I think it's helpful to remember, a lot of times people just go, no, 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 they just want to do that. And on this page particularly, there's places where you're only supposed to answer if you've checked yes to something above.
That's
so
right.
You really should be seeing some places, you're hoping, where there will be blanks on that document. All
That's
right.
a
So
good point.
be thoughtful of that. It actually shows the person's been thinking about it as they've been going through the questions and answers.
Right, and it's also a good idea to break up these questions because they're all kind of multi-part, or this, or this, or this. And I find that some clients would hear just the last part of that question and answer that, and it's good just to kind of break it down when you're completing the N400. There's a whole section here on part 11 that asks about their criminal record. So that'll be an important part to, again, break down each question into its separate parts and answer those yes and no questions that way. Okay. Let's see. Then there's also part 11, number 29, where the person actually has to list all the times that they've been arrested or detained. And again, hopefully people will come with their conviction records so that we can determine if we can help them and complete that part of the application or not. And then page 17 to 18, part 11, question 46. This is the question about the selective service registration that Greg had mentioned, where you have to fill in dates and the selective service number. Zipped along through
That's it.
much of this.
So what are the practical tips that you want to think about with, that's probably like 20 some slides, just some good moral character. First one is in terms of establishing, look at the date of the act not the court actions that occurred later on. So it's the date of the act that is the critical issue in terms of whether it occurred in the 3 or 5 year window. If you got a person who has that act that occurred 4.5 years out and they're married and have been married to a U.S. citizen and been a permanent resident the whole time, consider using the 3 year window then, and go back and make sure you use that instead of the 5 year window at the first page of the document. And on criminal records, never trust the person who's in front of you telling you that information. You have to see the documents. Those objective records are the things. CIS is going to have access to them eventually. They're going to require them to bring them into the interview, so you really need to see that. Just as a kind of a general thing, don't ever send sealed police records to the Immigration Service. Police records frequently include a lot of information that just never made it into the court documents, and that information can be used as part of the process for CIMT or anything like that. It's like admitting all the acts of a criminal event or something. So don't send those sealed records, and you have to make sure you see them. And again, there's going to be an attorney there who's going to be able to look at each of those things.
All right, so we have a couple of slides now on removal issues. Again, if these come up, obviously we won't be proceeding with these applicants at Citizenship Day, but just so you have them in the back of your head if you don't do removal work. This is sort of the third step when you're doing the good moral character screening. You're thinking about, is the person removable because of a certain act or conviction or conduct at any time since they've gotten their green card. So just listing a couple of forms of relief that you might want to screen the person for just to provide them some useful information. Even if they're removable, they might be eligible to get LPR cancellation, 212C relief, various types of waivers. I'm just going to skip that. What are some of the removal grounds? A big one is an aggravated felony, which is also a permanent bar to showing good moral character. But obviously we wouldn't want to present a case that had someone with an aggravated felony in their history. People who have a crime of violence with a 1 year sentence. Fortunately, assault 4 is not a crime of violence in the Ninth Circuit. Theft offenses with a 1 year sentence, even if they're not a CIMT under the recent case law, they still could be an aggravated felony. Offenses involving firearms trafficking, crimes of fraud or deceit where the loss to the victim was greater than $10,000. There's a whole list of crimes that constitute aggravated felonies. And again, the criminal attorney there can help with that. We had talked about false claim and voting issues as they apply to good moral character, and they can be kind of a discretionary issue, but they could also be a basis for removal for that person. And not necessarily being convicted of, unlawful voting. Just the act of doing it could make them removable. There are some limitations on false claim removal grounds. If it was before September 30, 1996, that they made a false claim to U.S. citizenship, that won't necessarily land them in removal. And also the Child Citizen Act exception applies to them. If they thought they were a citizen because their parents were, they were under 16, if they fit all those elements, then they could fall into an exception, and that they wouldn't be removable. If they vote in violation of the law, that can be a basis for removal, but that's very specific. You have to look at the mens rea of the statute they violated, whether it was a state voting law or a federal voting law. I think the federal law doesn't have a mens rea requirement, so that you violate it just by doing it. You don't have to do it intentionally or willfully or whatever. And again, the immigration officers kind of, that memo that Greg referred to, the person could still be removable for having voted, but yet they can show good moral character, and so you can sometimes convince officers that this person is eligible for citizenship and shouldn't be referred to removal because of the circumstances. But again, we won't be dealing with those at Citizenship Day, so let's move on. Other removal grounds to keep in the back of your head: if someone's been convicted of a crime involving moral turpitude within 5 years of admission to the United States, and the crime had a sentence of 1 year or more, that could be a removable offense. Certain firearms convictions, which could include just possessing a firearm, can be a basis for removal. If the person's had 2 CIMTs after admission, so maybe even back in the 80s or 90s, if they have 2 CIMTs way out of the statutory period, they could still be deportable, even if they could show good moral character. Controlled substance offenses, keeping in mind what Greg mentioned, even though marijuana is legal, or certain amounts are legal here in Washington State, it's still a problem for purposes of removal, or it could be, if it, depending on the amount. Violating a domestic violence protection order, just the finding by the court, not necessarily conviction, can be a basis for removal. Okay, a couple more. Crimes of domestic violence, that is fairly specifically defined in the immigration law. It has to be a crime of violence plus against a protected person. The person was inadmissible when they last came in. Maybe some inadmissibility ground applied to them, but it wasn't caught at the time. They could still be removable now. If they're a drug abuser or addict, this could come up in criminal records or in other ways. Or if they have been found to be smuggling aliens. They could be removable. So lots of things to keep in mind in addition to thinking about good moral character. The N400 contains various sections that are kind of trying to get at these, am I going down?
That's right.
To get at these issues. There's a section on page 8 that asks about marital history, and then there's also a specific question that says, have you married someone in order to get an immigration benefit? So you need to keep in mind when you're looking at how the person got their green card, who they're married to now, who they were married to then, did they get the green card through marriage? Think about those issues when you're looking at their case to see if maybe a fraudulent marriage might be an issue.
I had a couple of questions about that. Like, we generally are screening these days about how the spouse got status. If we're finding that in the course of the citizenship interview for the applicant, they're trying to backtrack to see that the spouse acquired. It's almost like they're assessing not only the applicants, acquiring a long-term resident status, but also the spouse. That might have petitioned them to question whether that person might have been properly acquired status, and I'm just wondering, is it going too far to be asking these questions at Citizenship Day? Because that's kind of what we do in our practice.
So the question was, they're seeing some cases where the spouse of the applicant is being looked at as far as how they got their permanent resident status, and then sort of working backward to see, if the spouse of the applicant's status is in order. So then I'm curious, what do you, are they issuing an N14
I
to?
think we've had consults, where they're just starting to go back and dig into the spouses and just trying to then question the bona fides of the original marriage between the applicant and their spouse. And they've been wondering if that's why in this new form they're asking for so much in-depth information about when they naturalized.
Mm-hmm. I mean, and I guess, so it's often the spouse, it seems like the applicant then would have an issue too if the spouse married them. Yeah. I don't know. I've seen, over a number of years, just a handful of cases where that became an issue. And I have maybe one current case where it could be an issue, but I think it's worth asking about both current spouses and prior spouses, just to kind of sift through and see if there could potentially be an issue. Keeping in mind that, people can get married for a green card as long as there's other issues. Is that correct? So it's kind of, it can be tricky, but I guess I hadn't run into what you're saying.
I had another question too about the criminal part, because I feel like there's this tendency when I'm at Citizenship Day to be overly conservative. I think because of that feeling like I'm not going to be there with the individual. So let's say the police report is really awful, but they're not barred. What do you think is the proper protocol if the police report is not very good? I'd almost be hesitant to send them for sale.
I think I would too. The question was if, it's hard to kind of determine at Citizenship Day if someone has sort of a borderline case, like they're eligible, but there are some police records maybe that are especially damning. What do we advise? And I don't know, you can chime in here too, Lily. I would say if the incident is outside the statutory period, I would never advise someone to submit police reports, and I wouldn't submit them with an application in any case. But if it's within the 5 years, then I would be hesitant. I think I would be a little more
I guess
conservative
my
about.
worry is if you don't submit it, they're gonna ask for it at the interview. And then there's no, like,
Right.
in that kind of situation, should we even be filing for them?
Mhm.
Because even if we don't submit it, they're gonna ask.
They're gonna ask, and then you'll probably end up having to write a statement about what were the extenuating circumstances and trying to overcome that, balancing. So, yeah, I mean, I think that's a good point. Maybe it's just easier to refer them to a private attorney who can help them with that up front.
I think just to chime in, like, being conservative is the way to go. And we obviously, we know that there are people that are turned away from Citizenship Day and we don't fill their N-400 out that are actually eligible for citizenship. And the idea is at least we give them a good list of attorneys that can help them and give them representation, because it's more important that they be successful ultimately. And if that means that they need representation, then that's what we should go with.
Why don't we go to the next slide, which is the removal issues number, yeah. Right. Yeah, there we go. Okay, so you'll see again the questions that we talked about before. Married to someone in order to obtain an immigration benefit, and it's like the number one thing. That's why I married that person. That's a big issue. Also, many misrepresentations. Again, these are issues that can be enough to warrant removal, so it's something to definitely be concerned about. And then on the next slide as well,
Oh, about deportation history.
Yeah, ever been removed, ever been ordered removed, placed in removal, all sorts of things. They really, as you see, this whole section 11, part 11, has really expanded on the number of questions that are asked, and there's quite a bit of really thoughtful, you really have to think about the answers to some of the questions, especially earlier on. Acquired citizenship. Occasionally during the course of Citizenship Day, you might find that the person actually is a United States citizen. So you always want to be sure to talk to them about, what about your parents? What about your grandparents? We want to go through the process. We have the books and the charts to be able to go through information, to be able to determine whether the person already is a citizen, and maybe able to get evidence of that through either applying for a passport or a citizenship document. So the new N-400 has a section where you can actually go through and help do that, and we've also got the charts that are available for you. And acquired citizenship, and here's the questions, 1 through 4. This is helpful because it's on the form itself. It gives you an opportunity to maybe determine whether the person is a U.S. citizen or not. And then another thing about citizenship, remember that the Child Citizenship Act does say that if one of the parents naturalizes and the child's under the age of 18, has been residing in legal and physical custody, and the child has to be a permanent resident, of course, that child becomes a citizen as of the parent's naturalization as well. So it's something that's helpful. It saves a lot of money. You don't want a child to think about having to do it on their own at a later time. And then we go to the next one. Is that where the... The children. So just on the issue about children again, sometimes when you're talking to people, they don't think about a deceased child, a child born out of wedlock, all sorts of other, a child who's not living in the United States. And they really need to make sure they present all the information about every single child that they ever had. So it's always important to do that. Make sure they know it and disclose that information as they go through it. And,
Oh, that's what I see.
yeah. All
Yeah.
right.
Well, this is just a section on how are you as the attorney going to sign the form on Citizenship Day? And we are, the practice has been that you're putting your name as the attorney and,
Oh, I can take this one.
okay, maybe you can because it's not what I
Yeah.
was thinking.
No, yeah. So because there have been a lot of questions from attorney volunteers in the past about like, how do we fill this out? And then the form changed and had more specific information. They were asking about the firm. Since you're not representing the person, outside of the advice you're giving them on Citizenship Day, we created a sticker that will be you can use at the end of the N-400 form that says that the form was completed at a pro bono group assistance event. You just need to fill in which site you were at, and that no G28 was submitted, and you're not representing them, and then gives the information about Ayla, Washington, and One America. But we do still ask that you fill out those first 3 lines. So your name, your information, your firm's information, and your contact information, so that we know we still ask that you are taking responsibility for being the person that helped with the form, and that we can get a hold of you if we have questions about why it was filled out a certain way or something like that. But that's why we've changed this a little bit to just be consistent all across the site so people know exactly how to fill it out.
All right, and then this last note is just about the interpreter statement. That's also much expanded on the new N400. If the person if the person is asking for a disability waiver or one of the English exemptions, the person who's interpreting at Citizenship Day should be signing off on this, and it includes lots of information. There's also a place. Let's see. The applicant has to sign it as well as the interpreter. So it's on 2 separate pages, I believe.
Mm-hmm.
So, oops. All right, I'm handing it over to Lily now.
Can I slide over? Yeah, okay. All right, thanks Greg and Emily for a quick and very informative overview of a lot of the legal complexities. So I'll take this last 10 to 12 minutes that we have to just talk a little bit about Citizenship Day and what to expect, and then we'll have some time for questions, hopefully at the end. As probably everybody knows, but maybe not, I just wanted to share, ALA Washington, the local chapter of ALA Washington was the first chapter to start doing these free pro bono Citizenship Day events back in 2004. And One America and the Washington New Americans program got involved in 2008, so we've been working together to do these for about 6 years now. But Citizenship Day is a pretty crucial event for people who want to become citizens but just absolutely can't afford representation. It's one of the few free programs still around. Even a lot of the nonprofit like BIA accredited organizations that provide citizenship assistance have to charge some amount of fees to keep their program running, and so for some people that's a barrier to being able to access this stuff. So we really want to keep the program going. We really appreciate all of you volunteering. There are an estimated 180,000 people with legal permanent resident status in Washington State that have had their green cards for at least 5 years. But then in a given year, there's usually about 17,000 naturalizations. So like less than 10% of people are actually going through the process. And especially out in Eastern Washington, we work with a lot of people who've had green cards since the 80s. And this is the only opportunity for them to take this step and do that. So obviously the purpose of the day is to help as many people as possible apply for citizenship who are eligible, but also to make sure that nobody who is not eligible or maybe has a complicated case or maybe removable moves forward with the process. So that's, obviously we want to help as many people as possible successfully fill out N400s, but we also want to make sure we're doing good screening, and that's what all of you guys are for. And of course, as with working with any clients, all of the information that people share with you is confidential. You'll sign a confidentiality agreement on the day, just saying that you won't share that with anyone else. And just a note that if you volunteered at Citizenship Day before, you know that it tends to be a little bit of controlled chaos. And so we ask that our volunteers be flexible, and you guys are always wonderful and flexible in terms of we may be busy, we may not be as busy as we expect, and we may need you to move around from one area to another, and just, be flexible, roll with it. It's a really fun day and it goes by really fast. A quick overview of how things will flow through the day at the site. There are 6 basic stations. Everyone will check in, and there'll be an intake greeting area. And at that area, they'll fill out the yellow intake form, which you guys who are in the office got a copy of, and then it was sent out on the phone as well. So be sure to review that form before the day so you know what it says. The first page of the form has a checklist for all of the different volunteer stations that goes over, all the different sort of reminders of what you need to make sure that you cover with the client. So we're going to ask that you check off those boxes and indicate your name on that form. So that's the way that we sort of keep a quality review, quality check of what happened with each client throughout the day. If they were referred out, why were they referred out? If they completed their form, great. But so they'll fill out starting on page 2, the clients fill out the intake form, and they'll fill out all that information, and there'll be volunteers helping them out, and that's also where we'll be doing the English screening. So if folks aren't eligible for the English waivers and they just absolutely speak no English, we'll probably suggest that they may want to come back at a later time after they've taken English classes. The second station is the forms preparation station, also known as the paralegal station, and that's where law student volunteers, paralegal volunteers, etc. will be to actually sit with folks and fill out the N400 form. And then the third station is where most of you will be to review the application after it's been filled out by the paralegals. And then we have our quality review station. So everybody who comes to Citizenship Day gets to talk to at least 2 attorneys, and that's one of our sort of quality of service items that we're really, really proud of and that we think is important, because you are only seeing these people once. You don't know their history, you're not seeing them again. We don't expect one person to be able to catch every single thing. We want everyone to see 2 attorneys so that we make sure that we don't miss anything. Assuming they get through all of that and their application's complete, it looks good, then they'll go to a copy station where people will help them make copies of their supporting documents, stop by our exit station, get all the resources they need, study questions, ESL classes, citizenship classes, etc. A couple other notes. We also have another station not listed on here that we call the special attorney station. That's where our crimmigration experts will be. And so, yeah, crimmigration. So we, anywhere on stages 1 through 4, basically, the person could be referred to the special attorney. We're going to try at intake to try to catch as many of those as possible. If they've checked on their intake form that they have arrest history or they have something like that, we'll have them stop by the criminal or special attorney first thing to see, is it actually worth them going and spending half an hour with the paralegal to do a 20-page form, or no, they have a mandatory bar, or they have some discretionary issues, or we're not sure, they don't have all the documents they need with them, they have to go, we'll give them information on how to get their documents and then refer them to our next event or to people locally who can help them out. So that's where our specialists will live. We use the term special attorney because we don't like to be in a room yelling, hey, this person needs to see the criminal attorney, because we don't want to use that language and stigmatize anything. So that's what that's about. Oops. And then there's also a role called the flow manager, which is the role that the One America staff will be playing that's at your site. And they will essentially be checking off the client in between each station. So after the intake form is complete, the flow manager reviews it to make sure it's been filled out. Do they need to see the special attorney based on what we can see here? Yes or no? After forms preparation, we check to make sure like the paralegals filled everything out, flagged everything for the attorneys, etc. So you'll be working with volunteers to help us communicate across large sites to make sure that we can check every single application. A few notes about what to expect. We ask our attorney volunteers to arrive at 9 a.m. So that you can get oriented. We'll be providing coffee because it's a long day, it's an early morning. Coffee, breakfast, lunch, everything. So you can come, get settled. We'll do an on-site orientation so you know where everything is, you know who your go-to people are. You'll also have access to a number of legal resources. Every office supply that you should possibly need will be there. There are binders that each of you will have with common things to refer to, like immigrant classes of admission, the derivative and acquired citizenship charts from Kurzbands. But if you have specific legal resources you'd like to have with you, feel free to bring them. But we should have everything that you need there. We open the doors to the public at 10 and we close at 3, but then we have to finish up with those folks that have come in. So we typically ask our volunteers to stay until around 5 or 5:30. A few things, if you volunteered before, that we're working on and always trying to tweak the flow and make things move smoothly. We've pre-prepared several common addendums, especially with the new N400 form. There's only space for like 4 children, for example, to be listed on the form, so we've pre-prepared additional sheets that have all the information you need to fill out about other children. Selective service, like Greg was mentioning, if someone didn't willfully fail to register but it wasn't willful, there's a form they can sign. So familiarize yourself with those addendums and those resources before you take your first client. If the client has any criminal history, we'll hopefully catch that if they disclose it, and we'll have them go to the criminal history before the criminal attorney before the paralegal. And then, just so you know, the first group of clients, we actually have them skip the paralegal station and come straight to the attorneys so that you're not waiting for like 45 minutes to get someone at the beginning of the day. So that first client, you may actually be the one filling out the N400, but then after that, you should expect to just be reviewing them from there on out. A few reminders, the intake form is super important, so please remember to fill it out, the relevant sections that you're responsible for. Everybody goes to the flow manager to make sure that we are providing quality service and everyone's going in order. And then at the end, hopefully everyone will leave with the packet from the attorney that says what to do next, how to mail their application, where to go get their passport photos, all of that. That'll be on site. You just have to go over it with them. And the completed N400. Or they'll get a slip indicating why they're not eligible to file and what they need to do next steps-wise. As I mentioned, there's binders and documents available. There's a box with other resources. And then you'll have every site has an attorney coordinator, so a designated go-to person, and there'll also be those special criminal experts and quality review experts that are very experienced volunteers. So if you have questions, feel free to ask. You'll have resources available. Quick note, and I won't go too much into this, but we will also be completing fee waivers for eligible people. We will only be completing fee waiver forms for people who are eligible because they either receive means-tested benefits, so food stamps, TANF, Medicaid, or their household income is under 150% of the federal poverty level. We'll be training our paralegals to do the screening for this and filling out the forms, but we sent out the form and brought them here, so please make sure you're familiar with the I-912 form and you've looked at it a few times so that you can review it, because you'll be wanting to review that along with the N400 form. So we'll be asking our paralegals to check the income against the cutoffs, check for public benefits, and they need to provide documentation, so proof of their income, taxes, things like that, or a letter from the agency that provides the food stamps or whatever. A few notes to be aware of with public benefits. Many, but not all benefits are not available to LPRs within their first 5 years after admission. So it could be kind of a red flag. There's questions on the N400 about fraud to achieve public benefits, but also if you see something and you're just like, gives you a weird feeling, that's maybe something that you want to investigate a little bit further. Okay. You have contact information for me and Sarah, who are from One America. And you have contact information for Megan and Maria. They're the this year's ALA Citizenship Day Committee chairs. If we could unmute the phones really quick in case there's any last minute questions from folks on the phone. Hopefully our tech people are listening.
You probably want them to just type the questions
Can
out.
you bring it to here? Tell me how to do it. We'll bring up the chat so you can just type in any questions you have. Okay. All right. I'm going to hand this. We have one question, and I'm going to hand it over to Emily and Greg.
All right, so this question says, is about the habitual drunkard bar to good moral character. Does the statutory deferred prosecution under RCW 10.05, where a person states they are alcoholic and needs treatment, cause a finding of being a habitual drunkard? Good question. Just being an alcoholic doesn't mean you fall into the definition of habitual drunkard. And I have never had that. I have had people who have gone through deferred prosecution for DUI within the statutory period be approved for citizenship. So it's not necessarily, it's something I guess to be aware of. And whenever someone has acknowledged they're an alcoholic, it could raise this ground. But again, habitual drunkard is more like chronic alcoholic, so it seems like there's a history involved there and repeated events. And the PS here says most people only do the deferred prosecution on their second or third DUI. So that would, I guess, indicate somewhat of a pattern going on there. I don't know that an officer is necessarily aware of that citation, the RCW she just cited. and there isn't necessarily anything in the record of conviction you might be submitting for someone who has a DUI that would indicate that they had acknowledged they were an alcoholic. So again, I feel like it's just because someone is an alcoholic does not mean that they are a habitual drunkard. Habitual drunkard seems to be a much higher level of alcohol abuse and use. So anything into that?
Any other questions? If you have them, you can type them into the chat. I don't know, we don't have our tech support people, so I don't know if it's unmuted.
Is it in the meeting tab? If you click that little speaker?
No, it's because it's a different sound system.
Oh.
If you have additional questions, you can email them to me and also to Megan, who's the ALA contact there, because she may have a better insight into the legal questions, and I can answer any Citizenship Day related questions, and I can also try to track them down. I can get a hold of Emily and follow up with any additional questions from there. But if there's nothing else, then
All guests have been unmuted.
okay.
I assume that we're filling these all out by hand, right?
Yes.
Apparently those are us.
Excellent. I'm glad you brought that up. Good question. So the question was, are we filling out the forms by hand or on a computer? And actually it depends what site you're going to be at. 2 of our sites will be doing them by hand, and 2 of our sites will be on the computer. And that's one of the things we'll be going over at that on-site orientation is what to expect and how logistically that will work. If it's an electronic site, you'll be saving the application on a little USB flash drive between the different stations. And then by hand, obviously, just by hand. And one thing to note with the new N400 is that it does have the smart barcode technology at the bottom. So if you do fill out the form electronically, everything that's recorded in the form will be recorded on the barcode. So then if there's something that you need to add that doesn't fit into what the spaces are on the form, or you need to put an additional note like about the travel, like I travel to Mexico once a week every summer for the last 5 years, then you do have to, well, it's a little bit tricky, like how are they going to assess that, because it won't be captured in the barcode. Our approach at Citizenship Day has been to create a cover sheet to go on the front of the N400 where you can flag for the officers, like there's additional information on page 13 that didn't fit in the spaces on the form. So, another question, yes?
I have 2 more questions. The first question was, I always forget the rule about this, if the person's green card's expired. I always forget about the procedure. They don't need to do an I-90, right?
No, they don't. I mean, there's that, I think it's a regulation that says if it's 6 months prior to expiration, or less than 6 months prior, you have to renew. But I mean, in practice, at least in this district of USCIS, if you're eligible for citizenship and you have an expired green card, just apply for citizenship, and there's no need to do an I-90.
And then the second question was about the exemptions. If the person is exempted from taking the test, the civics part in their language, when do they designate? Because there's nothing on the form, there's no place on the form to say what language they want to take the test in. Do they say that at the interview, or do they just assume if we use an interpreter, that's the language that's going to be used?
That's a good question. I don't think there's anywhere on the form. You mean if they would have qualified for one of the exemptions, but they're using an interpreter? Okay. I don't think, I mean, in general, people bring their own interpreters anyway, right? I mean, you can ask for one, and then they'd call the language line. But it would be a day of kind of thing. You bring your own interpreter, or if for some reason they couldn't, the officer would just dial in and get an interpreter.
I have a question regarding the oath of allegiance. I was actually surprised how many people have problems with that. And so, there will be people who will say, I'm just opposed anymore, and it has nothing to do with religion or just anything like that. Or something if, it's kind of funny, if the U.S. is bombing my home country, I'm not going to serve in any kind of form or manner. So when that happens at Citizenship Day, normally I would just say, you just make a decision, what's more important to you. What kind of approach should we take? Because sometimes when you tell them you're not going to be able to get citizenship, they will say, oh no, I'm okay with it. Or, so yeah, how should we? deal with that?
I've only had it come up one time, and so, but it was based on the religious grounds, so they were able to do it. But this district is a little bit more lenient, would you say? And some others are pretty strict about it.
Yeah, I mean, I've had people say that too, that they don't believe in war or fighting, and then I just sort of explain, so it's a requirement that your first loyalty will be to the United States if you're becoming a citizen. Yeah, and kind of what you were saying, I think, that you have to decide, do you want to be a U.S. citizen? Because, you're going to be saying under oath that you're willing to bear arms for the United States, and perhaps, and I've even had officers ask that question, if we are fighting Somalia, would you be willing to fight for the United States? So, I think you just have to lay it out for them, and then it's their decision.
And I was asked once, like, how likely will I be asked to do this?
And it's pretty unlikely, right? I mean, we don't have a draft right now. Who knows if we will in the future? I mean, a lot of my clients are elderly or well over draft age, so it kind of is only practically relevant for a number of people. But then it's willingness, right? You have the state of mind that you'd be willing to do that. So, I think it's not clear.
Any other questions?
I have a quick question about admission. How likely are the officers to try to get an admission if, let's say, there's admission, in a police record and you can't obtain a copy of the police report and you're worried about that? Like, what's from your experience? How likely that, during the interview?
I don't think it's very likely, but if a client hasn't, again, I wouldn't send a client in on their own if there was that, if there was something that they could admit to in their history and you were concerned about it, I wouldn't process them at Citizenship Day. If I have a client who maybe had something in the record that made it look like they were a drug trafficker or a alien smuggling or something like that, I would talk to them about, I wouldn't send them in alone. I would be concerned that it could come up. I don't think it's that likely, but it's always a possibility, but it depends on the issue again. Sorry, that's not a very definitive answer, but I would just say for purposes of Citizenship Day, if that's a potential issue, I wouldn't send them forward.
I'm just wondering if on the Citizenship Day, client can and they need to submit some documents, for example, the marriage certificate, but they only have the version from their own country, they don't have the English version. What should we do at that time? Should we send them away or should we prepare everything?
Well, so the question was if they only have their marriage certificate, but it's like not the English, they don't have an English translation of it, it's just the original or something like that. They show up and they don't have the document that's going to be needed eventually. You only need that if they were applying based on marriage to a U.S. citizen anyway.
Yeah.
And so, if that is the case, that's required to be sent with the N-400, right?
Yeah, or significant.
Yeah.
And
So you want to make sure that they could get it in time to bring it to the interview if they can't send it right then. But I would say fill out, if that's the only issue, you can fill out the N-400 and make it very, very clear to them, you need to get this translated, this is how you do it, before you put it in this envelope with the N-400 and then send it off.
So where can they go for the English version?
It depends like what site you're at.
You mean for like translation services? Yeah, I guess it depends.
Yeah, I think I would need to do some research to find out like what. Yeah, but you would just need it just needs to be like a certified interpreter. Or
and it doesn't even have to be a certified interpreter.
Okay, it can
translation. I just basically, some people I just say, if you speak the language and knew other people to do it, for me the easiest thing to do is translate everything into English, first of all. Seals, everything on that document should be translated. You don't want any aspect of it that's not translated. Get that translation, and then we fill out a document that says, I certify that I speak both English and whatever the other language is, and that the attached document is an accurate translation of, and then name what that document is, and then they sign and date it. So like,
So they can do it.
one person might have done it themselves, but I don't like having the person who is the subject of the filing also doing the translation. So I say, but sometimes doing the translation takes a lot of time and effort. So I say, go find another friend who also speaks these two languages. You do the translation, have them confirm that it's actually accurate, it has everything on it, and then they can sign it. I didn't say that I did the translation. I just certified that the attached is an accurate translation of the two. And that works. I've never had anybody have any problems with that. But I have had problems where people have failed to include the terminology on a seal or some other aspect of the document. They think, well, that's not part of the standard form, so I won't translate that. It can have some important information in it.
Oh, yeah, that's much easier. I saw you need to go to like the embassy.
You do not have to pay.
Government of the like Chinese government.
Yeah, you don't have to pay a certified translator. They don't have to be a professional translator. They just have to be able to certify that they speak and understand both languages.
I think like say for example China, you still have to look at the reciprocity table. Like they require like say a birth certificate in certain format, like say from China.
Well,
yeah, right. Like you couldn't just bring a hospital certificate and just have your friend translate it and submit it.
so the question is about the document itself. So the document itself has to be one of the documents that is an acceptable marriage certificate or an acceptable birth certificate. I don't see if we do birth certificates, but so it has to be one of the documents that works. But the translation doesn't have to be a professional translation. So yeah, a person can't just bring in a handwritten note that says, I was present when Greg was born on such and such date. No, that doesn't work. Although actually, in some senses, those things can work with a number of affidavits. But yeah, the translation itself can be non-professional.
I was just going to suggest that maybe the certificate of translation should be included in the
Yeah,
attorney's
we were
binder.
just talking about that.
Yeah.
That would be something that we could easily put the
Especially if
example.
you had someone who can do the translation right there on the spot.
Yeah,
Or even a birth certificate template that has all the pertinent information.
yeah. Not going to guarantee that we'll be fully prepared by the 18th, but by the next one, we can definitely do that. Okay. Thanks, everybody.
Thanks.
We'll see many of you on the 18th at various different sites, and thanks again.